heard you say, and you tell me if this is accurate, that sometimes when a file comes to you from an investigating agency, that it is not always, in your words, complete.
Yes.
And you testified, did you not, that it would be your job or your duty, your responsibility to do some additional work. That may not be the word you use. You may have said investigation. I'm not sure.
I understand. Yes. If it's not complete insofar as we don't believe that it would be appropriate to present it to a grand jury and subsequently a trial.
Right. Because of course, your interest as an assistant district attorney is to make sure that cases are properly put before the court or put before a jury. True?
Correct.
And in fact, when you, one of your duties as a district attorney is to make sure that there is sufficient evidence or appropriate evidence presented in a case that goes before a court, goes before a jury. Correct?
Yes.
All right. Because it is important to make sure that people who need to be prosecuted are prosecuted, right?
Yes.
It is important to make sure that people who should not be prosecuted are not prosecuted.
That's correct.
You do not want, and your duty, I believe, encompasses this, you do not want to have someone charged or arrested or their freedom taken for an offense that they did not commit. True?
Overruled.
Is that true?
That's true.
Okay. And so I want to talk to you about a number of things, but I want to start by asking if I'm correct that when you came into this case in 2016, the case had already been with the detectives Gaither, Dennis, and Thorpe, right?
That's correct. Those were the detectives that primarily were the ones that I knew of that had been working on it, yes.
Work had already been done on the case as far as you knew.
Yes.
In fact, people had already been arrested in this case.
Yes.
And I'm talking specifically about Donovan Thomas's murder.
That's right.
You were looking at.
That's right.
And so you knew by the time that you came into this that there were 4 people who were sitting in the Fulton County Jail who had been charged by the detectives whose name we've just referenced with the murder of Donovan Thomas.
That's correct.
Kenneth Copeland, Shannon Stillwell. Who else?
Antonio Sledge and Demikian Garlington.
All right. Those people, as far as you knew when you picked up this file, had already been investigated by the detectives, true?
That's true.
And by the way, you had worked previously. I mean, you knew who detectives Gaither, Dennis, and Thorpe were. You know who they were.
Yeah, I knew who they were, yes.
You worked with them previously.
I had.
Right? And so you came into this with people arrested, believing that the work had been done properly to have 4 folks in the Fulton County Jail, all right?
Well, that was my hope.
Right, right. That turned out not to be the case, right?
Correct.
In fact, tell me if this is right. I think you testified to this, that there was the interview of this gentleman named Spencer Wright. October the 19th of 2015?
That sounds right, yes.
All right. And that
2015, did you say 2015?
2015.
Yes, yes.
Okay. And that interview was done by Detective Thorpe, correct?
Correct.
And the next day, the 20th, is when Detective Thorpe went in front of a judge and got an arrest warrant for the 4 people whose names we've just mentioned.
Yes, yes, that's correct.
Right. And those 4 people were put in jail as a result of the investigative work that had been done by those detectives whose names we've just referenced.
Well, I would, when you say those detectives, I would not, Detectives Gaither and Dennis, I wouldn't group them into that. It's Detective Thorpe that was the affiant on the arrest warrants for Mr. Sledge, Mr. Garlington, Mr. Copeland, and Mr. Jackson, aka Mr. Stepwell.
Right. So one person swore out the warrant. That was Detective Thorpe, right?
That's correct.
But you're certainly aware that over the course of the investigation from January of 2015 to the time that Thorpe went and took out that arrest warrant in October of 2015, that he had communication and collaboration with Detectives Dennis and Detective Gaither. You know that, right?
Well, he sat in on interviews with them. Some of these interviews that we've discussed, or I discussed on direct. So, yeah, and they work for the same agency. So yes, I would say yes.
Right, and looking at your, what you've termed, maybe we've termed, the Sprinkle Report, right, where you kind of reviewed this case, looking at that report, you know that there were times when, for example, Thorpe would go and consult with either Gaither or Dennis about a particular individual that they were investigating. True?
I don't. It would seem like it would seem that would be the common sense thing that would have happened. And I'm not trying to be difficult, but I don't know what kind of I don't know what kind of conversations Detective Thorpe had with Detective Gaither and or Detective Dennis.
Okay, well here's a for instance. You know that there were interviews of Kenneth Copeland where Thorpe, Gaither, and Dennis were all present.
Yes.
Right? And in fact, what was it, 9-10 hours worth of interviews of Kenneth Copeland?
There was one interview that was over 9 hours long. So, and there were multiple interviews with him. So it was over 9 hours. It suffices to say.
Right. So getting back to my, the question I asked a little while ago, you certainly had information that these three detectives, Thorpe may have been the one who took out the warrant, right?
Yes.
But these three detectives were in contact, in communication with each other in regards to Donovan Thomas's murder. You knew that.
Yes.
Right. And ultimately, what happened is that they arrested the wrong people, didn't they?
Vagueness in the word they.
Okay. Ultimately, the warrant that Detective Thorpe with the Atlanta Police Department, after consulting or talking to Gaither and Dennis, took out for these four individuals, charged the wrong people with the murder of Donovan Thomas, correct?
To that question, Your Honor.
When you, one of the things that you did when you first began to kind of look into what had happened in this matter is that you realized, and you said this in your report, if I'm wrong, maybe I'm reading it wrong, you correct me, okay?
Okay.
But one of the things that you said in your report is that it seemed as though the arrest of these individuals, and by the way, these folks were arrested. I mean, they weren't just like suspected. They were actually put in jail, right?
We got that.
Okay.
Go ahead and ask your question.
All right, get in there. You said that this was almost entirely based on the statement of Mr. Spencer Wright.
Yes.
Right?
Yes.
Okay. And it turned out that Detective Thorpe, or whoever else was involved, did a ridiculously poor job of vetting or looking into Spencer Wright's statement. Isn't that true?
Well, there was surveillance video that Mr. Wright said he was a specific place, and there was video that would have showed whether or not he was there. That apparently was not inspected very closely prior to obtaining arrest warrants.
Right, well, in terms of not investigated fully, Spencer Wright, Thorpe spoke to Spencer Wright on the 19th of October, right?
Yes.
Now, when you came into the case, one of the first things that you thought to do was to really examine the statement from Mr. Wright. Is that true?
Yes.
And you did so?
I did.
And you spoke to him?
I did.
One of the second or third things that you did, right, just using some common sense, was to go and look for video around the location where you thought Spencer Wright would have been, right?
That's right.
And you did that.
I did.
And you were able to find it.
I was.
And it was pretty easy.
It was.
Detective Thorpe, before arresting folks based on your words, almost entirely the statement of Spencer Wright, never took the time to even go look for video where Spencer Wright supposedly would have been, did he?
Well, that I don't know. You would have to ask Detective Thorpe that.
Well, did you? Did you ask Detective Thorpe that?
Oh. I'm sure I did.
Let me guess. The answer was that he had not done it, right?
I remember the answer he gave at the preliminary hearing about the video.
Okay. Well, let me ask you this. When you come into the case in 2016, was there any video that had been procured from that location by Detective Thorpe? Where the bus stop, where Spencer Wright
Yes.
would have been?
Yes.
Was there?
Yes, there was a video camera, and in the viewable area of that camera was the bus stop where Mr. Wright said that he was standing at the time of the homicide.
Right. Had anyone gotten that video?
Yes.
Who did?
It was, yeah. The specific investigator was probably either Frederick Page or Jason Teague, but ultimately it wound up in the possession of Detective Thorpe.
Okay. Before these four individuals were arrested or after?
Before.
Okay. And so even having the videotape that you looked at and that you made a determination was pivotal in the arrest or in the case, even having that information, Detective Thorpe still went ahead and swore out the warrant for the wrong people on October the 20th?
That's right.
Welcome back to the channel. What is going on with the goings on with the YSL trial? All hell broke loose yesterday. The judge was fired up since the opening of court yesterday morning. Love could not get a break. She continued with misconduct all day yesterday and was called out on it. So let's get straight into it. Please subscribe, please hit the like button, please turn on your notification bell so when I get the drop, you get the drop, and we only bring truth from this channel. Let's get it.
Your Honor, so my well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't see.
yes. First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with what was the comment? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him to
Honor,
testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this social media page.
You represented at the bench that none of this, that being the writing on the right, which we're all squinting at because it's tiny on the piece of paper, and so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no, and then you turned around, and after it was admitted over the overruling of the hearsay objection based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked it.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous, because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. State being very slippery in regards to their response. Willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide ride the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you put the case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
So in actuality, this stems back to Sunday when Love emailed the judge and called her out on some rulings and wanted to go back over those rulings. So the judge came in Monday morning already on one. So yeah, let's continue.
All right, Miss Love, in your Sunday 6 p.m. email, you said that you were going to forward later in the evening to counsel and the court the portions of Mr. Zachary's interview that you were seeking reconsideration of based or because of, I guess, the way he testified. I'm not in receipt of that forward. Did you ever forward what the actual portions are?
Your Honor, I think, no, I forwarded the transcript, the corrected transcript that I was seeking.
But you didn't forward the portions that you had that either I had ruled out or you had agreed would be out?
I did not forward those. There were,
and yet that's what you expected everybody to argue this morning without even knowing what those were. Could you please forward those at your earliest convenience so that we will know by lunchtime what it is that we're talking about?
absolutely.
Excuse me, and I didn't receive the transcript last night.
Well, she's agreed that she's not going to be using the transcript because nobody's had a chance to look at it. So you don't need to worry about that.
Thank you, Your Honor.
But I don't know if somebody's going to be over here to assist you later in the morning, but as soon as somebody gets here, you need to get that taken care of, okay?
Yes, Your Honor.
All right, so is Mr. Sprinkle out there ready?
He said that he needed 10 minutes from the time that I reached him. So
Tell him, text him now and tell him he needs to get over here right now.
he is, Your Honor. He is coming. He
Text him
literally,
anyway and say the 10 minutes, he can't have any more time. He needs to stop what he's doing right now and come on. Because we have the jury waiting.
yes, Your Honor.
To address something?
Yeah, just briefly, Your Honor, and I'm not sure when the state plans on using this, but on the 27th of September, so what, 3 days ago, we got a Dropbox link with additional crime scene photos from a 2019 case, a 2014 case, and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to the case numbers. I think they could give you more detail.
Okay.
My main point being these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And it seems to be my role in the case. I'm here to once again complain about late discovery, Your Honor.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein
You get
referred
those
to.
files at lunch. Seems to me like
We
we're
can
going to
do
have a
that.
lot to talk about over lunch.
We can do that, Your Honor. And also, I will say that those are, to the extent that Of course, I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over is a direct result of matters and witnesses that we have added back because of the objections that have been made. And the CAD reports, I believe, have already been admitted as evidence. So there is nothing about the photographs that would create any delay or prejudice or anything of that matter, but I'll address it at lunch.
What were the dates?
These are cases from, according to what Mr. Atkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Atkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
Okay.
Continuous misconduct by the prosecution team, but let's listen to the judge.
All right, I'm going to deny the motion from this trial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter before the record for the court.
All right.
Your Honor, this is from United States versus Roberts, ROBERTS, 40F 2nd 255. It's the 9th Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing: is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
So I don't know what they think, but I will say this. This is not incumbent in the state of Georgia of the trial. And it is all the time, Your Honor. It's all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume other people on trial will agree. This is constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing the court, and I think it does rise to the level now, but I am saying people, I think that we're well beyond it. And the reason I said the whole statement is clearly.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
But with that ruling, all she did was make the defense go hard. Let's get it.
I wanted to jump back to. Remember we talked a little while ago about Mr. Copeland giving a statement about a conversation between he and Garlington the night of the incident?
Yes.
Okay. You recall from listening to Copeland's statement that he references that the night of the incident, he's supposedly to McDonald's and he makes a phone call to Garlington, right?
Yeah. That's right.
And you recall from his statement that Copeland also says that he ended up in a vehicle with Garlington and McMullen. You remember that?
I do.
Okay. Now, back again at judging the veracity of the statements people give to you, specifically now Copeland, you were able to determine that at the time when Copeland says that he is in a car with Garlington, that Garlington's phone, or the phone you think is Garlington's phone, is actually calling Copeland's phone at that time. You remember that?
No, I'm not sure. You must be referencing Mr. Copeland's cell phone call data records, and there's a phone call at a specific time that somehow occurs at a time when I don't know. Is that what you're talking about?
That is, let me see if I can break it down anymore. Copeland gives a statement saying that he spoke to Garlington on the night of the incident, right?
Yes.
Copeland gives a statement saying that at some point he's in a vehicle with Mr. Garlington and Mr. Demise McMullen. True?
That is correct.
All right. Looking at the phone records, right, at the time when Copeland says he is in a car with McMullen and Garlington, you actually see phone calls between Garlington's number and Copeland's number when they're supposedly in a car with each other, right?
Well, so first of all, what number are we talking? Would you like me to say which number I believe may have been Demiki and Garlington's?
Sure. Go ahead and tell me what number you're talking about.
It was 404-621-0102. That would have been the pretty much the only number during that immediate aftermath of the homicide with which he was in contact. And there were routed calls. Well, I won't get into that, but I had some what I believe to be limited tower location data for that 404-621-0102. But the calls, there was an inbound call where that 404-621-0102 rather, 621-0102 called Kenneth Copeland at 7:51 p.m. and 36 seconds on January 10th, 2015.
Right.
Now, you'll see, now again, if in fact that was Mr. Garlington's number, There were some routed calls. There were between, but a routed call is not necessarily a communication between the two numbers. It could be a call, an attempted call that wasn't completed. So, but as you would have to ask Mr. Copeland, you know, about those phone calls and where he was, and if Mr. Garlington was actually in the car with him, or he was inside, you know, the convenience store or the McDonald's or wherever it was they said they were. I don't know. I just don't know.
Well, okay. Let me ask you if you know this. All right. Again, we agree that according to Copeland, he, McMullen, and Garlington are in a car together, right?
That's what Mr. Copeland said. Yes.
Okay. And there is a phone call. Let's not talk about Copeland. Let's talk about Garlington and McMullen. There is a phone call between Garlington's phone. That's the one that you've referenced, the 0102, right? That's
right.
what you believe is Garlington's phone, right?
That yes.
And there is a phone call that connects between Garlington and McMullen's phone at the time when they're supposedly in the car together, according to Copeland.